Hi, everyone. Harry here to talk about Fani Willis's motion for clarification to Judge McAfee about the scheduling in the trial. It sounds like it's kind of very picayune. In fact, it's not. It's both clever and important. All right, so recall, Ken Cheseboro makes a motion for speedy trial. And under Georgia law, that gives him the right to go to trial no later than the next grand jury session. So he gets to trial, and a trial has now been set for him. It has to start, the jury has to start by early November, and that means the schedule now is to start sitting a jury at the end of October 23rd, I think. And by the way, he has now been joined in this, probably to his chagrin, by Sidney Powell, and John Eastman is coming. So this lifeboat that he thought he would take on his own is now overloaded with some maybe unwelcome co-defendants. But the point is, getting a speedy trial doesn't mean you get severed from everyone. So motion to be one, the speedy trial gives you the right to a quick trial, but it doesn't give you the right to a separate trial. That's what severance is about, and that is a separate analysis. So the judge here, Judge McAfee, grants the speedy trial, says this is just about Cheseboro for now. But Fani Willis comes in at the time and says, fine, he's got the right, so we will try all 19 then, which seems kind of crazy. But for one, it's kind of showing, it's kind of a, tough prosecutor's move. We're ready. But it's also kind of a situation dictated by the law, or at least pushed in that direction. Because look, the 19 are here with nothing set. Cheseboro gets his trial in November, but these guys right now have to go with them until they make a motion to sever. And the thing about a motion to sever is it's not automatic. In fact, the law is pretty clear. It's often defendants who are trying to sever. They want to be tried alone. They want to point the finger at another defendant who's not in the courtroom. Prosecutors want the opposite. They want them lumped together, pointing the finger at one another. And the law says defendants don't get a motion to sever just willy-nilly. They've got to make basically a showing that there's something that makes it deeply unfair to try them together. A classic example: one of the two made a incriminating statement that also brings in a co-defendant. But that statement would be, under the rules of evidence, admissible against defendant number one, but not against defendant number two. But if the statement comes in, Lisa and I robbed the bank, even though Lisa didn't make it, she's sitting there, and the jury, of course, even if the judge tells them not to, will consider it against Lisa. That's a situation to separate things. And there's a couple others that are like that. And what Fani Willis is saying is, Judge, you've got to go through these motions to sever individually, and they've got to make these showings. And by the way, that's good for Willis, because they may well have to show their hand about what their defenses are, because another factor is if the defenses are, inextricably contradictory. And until you do that, everyone is lumped together. So it's weird, for one, and for two, you cannot believe, it seems highly implausible, that McAfee would say, oh, okay, well, I grant the speedy trial and no severance, so everyone get ready for trial October 23rd. But how he's going to exactly handle the motion is a challenge, because the factors that are given for severance under the law and that courts apply don't include, this is too soon for them. They don't want to, they're being rushed. That's a due process consideration. And presumably the Georgia law that says speedy trial means, you have it in October, says that's enough under the due process clause. So he's in a bit of a puzzle. we haven't heard back from him yet, or I'm sure the other defendants will rush in trying to make some suggestions, including Trump, who we know for sure will move to sever. But they're going to have to make some showings. And the real thing going on here, which is this is just giving them too little time, isn't the sort of showing that you normally make. So how McAfee is going to handle it and how the 18 are going to handle it is going to be an interesting issue to see. And I think it's hard to square exactly with the law as it's stated, even though at the end of the day, it seems like he will figure out a way that to separate out the defendant. So one more thing, though, it's an individual inquiry, right? Each defendant has to make it. So presumably this is the one trial date that's anchored. So everyone is glommed on and stuck to there. And if one person peels off, that doesn't mean these guys all do. They're all each going to have to show it. And Fani Willis is saying, and do it quickly, so we can get our trial people in order, who's going one and who's going the other. And that's also going to push the individual defendants to have to kind of reveal their hands a little bit. So a tricky puzzle for McAfee and a clever motion by Fani Willis, as well as a doubling down on her position. We're ready to go. Let's all 19 go in October. Can't see it happening, but can't see exactly right now how he decides otherwise. So stay tuned. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.